Hi, my name is Chris Nolan. I'm a barrister at Queen Victoria Chambers in Sydney. This video is called How to Amend a Police Fact Sheet, and it's designed to assist legal practitioners in the local court of New South Wales. Before a court can sentence an offender, it needs to make a finding of fact as to the circumstances of the offence. If the client pleads not guilty, then there's a hearing and all these facts are determined on the evidence. However, if the client pleads guilty, then there is no hearing and no evidence. Instead, the client is required to allocute, that is, to say what they did. And they do this by way of a police fact sheet. Now, a police fact sheet is a narrative of what the police allege to have happened. However, often in this narrative, there's all kinds of material that is either irrelevant or objectionable and should be removed. And no guilty plea should ever be entered until the best possible set of facts has been negotiated with the police. Every line of the fact sheet should be passed to see if it is see if it meets the rules. So the first rule is relevance. Everything in that fact sheet must be relevant to a charge on the indictment. Now, police will often include extraneous material in order to paint the accused in a bad light, and this might include allegations of other offences that haven't been charged, or allegations of conduct that is immoral but not illegal, or allegations of previous suspected offending, or allegations of consorting with undesirable people. Now, all of these allegations should be removed because they're simply not relevant to the offence charged. The reason they're often in a fact sheet is that the fact sheet has two purposes. One, for the court to make a finding of fact sentence, but also it's used at any potential bail application, and that's why they throw in all this irrelevant material. The second rule about what goes into the fact sheet is opinion, the opinion rule. It is a fact sheet and a statement of the facts, therefore it should state the facts of the offence and not include any opinion. But the police often will throw in their own 2 cents worth. And for example, they might say something like that the defendant is a recidivist criminal, or that he has no respect for the law, or that his actions place people in danger. Now, all of these opinions can be put to the court in submissions by the prosecutor, but they are opinions. They are not facts, and they should not be asking the defendant to agree with them, because one, he might dispute them, and otherwise he might have some explanation as to why he did it, why it was necessary in the circumstances. The third rule to have regard to is the rule in De Simone's case, and that rule says that a court cannot take into account as an aggravating factor a circumstance that would warrant a conviction for a more serious offence. So if a prosecutor were to accept a plea to a less serious offence in full satisfaction, then they have to they have to amend the fact sheet so that it reflects the new less serious charge and not the more serious one that is withdrawn. The fourth rule relates to facts that are in dispute. If facts are in dispute and the client will not admit them, then the fact is not agreed and should not be, and the matter should not proceed as a guilty plea. Instead, the matter should be listed for a disputed facts hearing. Now, if the police fail to prove that disputed fact, then the defendant should be entitled to the full discount for offering his plea of guilty in the first place. In reality, disputed fact hearings rarely ever take place. The reason is that either the police will remove the disputed fact or the defendant will plead to it to avoid the expense of a hearing. Now, some of you might be sitting there thinking, well, this is all rather obvious and I knew this already. I have seen some absolute horror stories in district court appeals. Clients have gone to the local court and they've been absolutely smashed on sentence. They've filed an appeal. I then come into the matter and look at the fact sheet that's been handed up, and some of them are absolute horror stories. It is clear that a lot of practitioners are not aware that they can amend a fact sheet or how to go about it. And that brings me to my final thought, which is this: be flexible. Remember at all times that it is a negotiation, and it's not about you trying to show how smart you are or put one over on the police. It's about getting the best possible result for your client. And so it may be that you can give ground on one point in order to gain ground on another. At the end of the day, the goal is to get the best result for the client and not to demonstrate how well you know the rules. Thank you for your attention.